All right, court will sentence you to 1 year in the Bexar County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no.
I don't understand what's going on here.
But I'm not gonna be able to have my kids.
2023
I'm
CR
not your attorney.
0042, State of Texas versus Brittany Merrill Brown. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
And
And are you Ms. Brown?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Brown, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Did you understand that the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation as a class A misdemeanor? The range of punishment is up to 1 year in jail and up to a $4,000 fine. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I did not understand that one.
All right, you don't understand you have a right to jury trial?
I heard it, but I didn't hear it.
All right, so do you need to speak to your attorney?
No, can you please repeat?
From the start, you can feel the confusion. Brittany Brown is standing there, facing a year in county jail, and she doesn't even fully understand what's happening. This is a critical problem in our justice system. Defendants often agree to deals without truly grasping the consequences.
Right to remain silent.
Yes.
And did you intend to do that and enter into a plea bargain agreement today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bexar County Jail. State recommends community supervision. There's an affirmative finding of family violence. I'm going to need you all to be quiet in the box, please. There's an affirmative finding of family violence. There's to be no harm for or injurious contact with Tegui, Tegui, Bizu, Biezou. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? You're not allowed to own or possess any weapons or ammunition. Do you understand that?
I mean, yeah, but I can never for protection.
You need to speak to your attorney about that. But with an
Okay.
affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
Okay.
Do you understand?
Yes, ma'am.
This part is heartbreaking. The judge is explaining that a family violence finding means she'll never be able to own a gun, and worse, she could lose custodial rights over her children. You can see the shock on Brittany's face. It's like no one had told her this before. Imagine thinking you're just pleading to get probation, then learning it could affect your family forever.
Understand that.
This is the first time I heard of that.
All right, so I'll let you all step back so you
So
can,
what does that mean?
I'll let you
That
speak
I'm
to
not-
your attorney about that.
I'm not allowed to have children?
Oh, you can have children, but if there's some sort of custody issues that arise, technically and legally, the court is not allowed to have you as primary custodial parent. Now, if in the best interest of the children, they determine that you will be the best placement, then they can do that. But if there were any type of custody issues and there's a person who appears to be a good parent and they don't have an affirmative finding of family violence, then they're supposed to be designated as primary custodial parent. I'll let you speak to your attorney about it. So I'll have you all step back and you can talk to your attorney. All right, so we're back on the record. In 2023 CR 0042, Brittany Brown. We were on the plea. So did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of the plea bargain agreement? I don't understand what's going on here.
But I'm not gonna be able to have my kids?
I'm not your attorney. So the only thing my job is to make you understand what the plea bargain agreement is. I've explained to you with regards to the meaning of an affirmative finding of family violence. And I always give people those instructions so they will know, because many times when people enter pleas on the criminal sides, they have an impact.
Reaction is raw. She blurts out, "So I won't be able to have my kids." The judge tries to carefully explain the civil consequences, but Brittany isn't hearing legal jargon, she's hearing that her children might be taken away. This is the kind of moment that shows how devastating even reduced charges can be.
All right, this is what I'm gonna do. I'm gonna have you all take a seat just to
No, ma'am,
talk it out
I
more.
do understand it, but it's just it's a horrible thing for like to have this horrible. So I understand it, but
I mean, all the cases here are horrible. They're felony cases.
I thought it was getting reduced.
It's still getting reduced, but it's still, all these cases have consequences. Whether it's being reduced to a misdemeanor or not, there are consequences that flow from felony cases and consequences that flow from criminal charges. So what I'm going to do is I'm going to have you sit with your attorney, because I want you to, if you're planning on entering a plea in this case, I want you to enter it with a clear conscience and a clear understanding. So it appears to me, and I may be wrong, I'm making assumptions here, that you didn't know the consequences civilly of entering a plea in this case. And the fact that you're talking to me about, am I ever going to be able to possess weapons? Am I ever going to have my children? That's something that you need to discuss with your attorney, and it needs to be in a setting. I don't want to say without passion or objectively, because I know these are all personal matters, but it needs to be something that's thought about with clear head and something to think.
I respect this judge here. Instead of pushing the plea through, she pauses and tells Brittany to talk it over with her attorney. That's rare. Many courts are about speed, not clarity. Here, the judge acknowledges that Brittany clearly doesn't understand the long-term impact.
Requesting that you defer adjudication be for a term of 2 years. There be 100 hours of community service restitution, the BIPP, a TAP evaluation, and follow all recommendations from the TAP evaluation. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yeah.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, sir. At this time, state up for state exhibit number 1 and its attachment.
No objections, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He has had the problem, I guess, communicating and understanding what is happening, but after explaining several times for the situation, she understands everything, and we're asking that the court accept the recommendation from the state to place on deferred.
All right, what was your warrant for? In the police report, it says that when the complainant called the police showed that you had a warrant. So what did you have an active warrant for?
It had been for a failure to ID.
All right, state, can you see if there are any pending charges other than this case?
Yes.
Yeah, there's a failure to ID. Oh, sorry.
Your Honor, there's a failure to ID, and that one is for the state would be TIC.
It's not listed in the plea.
Judge, there is, but we can, I can tender a dismissal. I think you just give me a couple months to fill out a dismissal.
All right, thank you. All right, are you employed?
At the moment, no, I'm not.
How do you support yourself?
I'm living with family right now.
What family is this?
My mom.
All right, and Child Protective Services were called. Is Child Protective Services involved?
Yes.
All right, this is what the court is going to do. 2 years deferred adjudication. There's an affirmative finding of family violence. Well, let me strike that. The state is requesting that actually you have a conviction. What the court can do is you can have a conviction. That's what you bargained for, or either I can give her deferred adjudication.
Leave a. Rules for deferred adjudication in your ask for.
All right, if the court were to give you deferred adjudication, if anything were to happen and your probation were revoked, you could end up with potentially 1 year in the Bexar County. State has offered you, if you were to not do well, you could still end up with 1 year in the Bexar County Jail. So which would you prefer? Would you prefer conviction or deferred adjudication?
Conviction.
All right, court will sentence you to 1 year in the Bexar County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no.
Sorry.
This is the most dramatic moment. Brittany accidentally asks for a conviction instead of deferred adjudication. The second she realizes it, she breaks down, repeating, "Oh my God, no, 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 no." It's almost painful to watch. One word could have changed her entire life. Thankfully, the judge clarifies and lets her correct it.
Court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Tagai Buzu. If there are some kind of child custody arrangements that need to be made, you'll need to make those through a third party. If you wish to have contact with him, he'll have to come in to court, and I'd have to hear some evidence with regards to that. There's to be 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to request parenting classes. CPS should give you parenting classes. CPS compliance. Probation, if CPS is giving her parenting classes, then she can, then the court will accept parenting classes from CPS for her. There's to be the BIPP course, TAP evaluation. And whatever the TAP comes back with, we'll start with supportive outpatient treatment. And again, if CPS is giving her alcohol treatment or drug treatment, then CPS can do that, and that'll be acceptable. Regular UAs, I'm going to want field visits at least one time per month until further notice. Regular reporting in person or by Zoom. Proof of employment within 15 days. There's to be no employment as a home health care provider or with.
The final sentence feels overwhelming: probation, CPS involvement, parenting classes, community service, restrictions on jobs. For someone already struggling, that's a mountain to climb. And yet, this is considered the lighter option.
Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yeah. All right, good luck to you. Court is calling 2023 CR 0042, State of Texas versus Brittany Merrill Brown for the state. And are you Brittany Brown?
Yes, ma'am.
Are you the same Brittany Brown who was placed on deferred adjudication in 2023 CR 0042 for the offense of assault, bodily injury, married on February 6, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
And did you review that motion with your attorney?
Yes.
All right, state.
Your Honor, on or about the 6th day of May 2024 in Bexar County, Texas, the defendant, Brittany Merrill Brown, did then and there fail to follow all TAP treatment recommendations as directed by the court and or Bexar County Community Supervision Department in violation of condition number 15.
How do you plead to that? True or not true? All right, did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bear County Jail. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 15?
Fast forward, and she's back. This time for violating probation. Brittany admits it's true. At this point, the system has already marked her, and every misstep piles up.
You give would be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, yes, what would you like to say?
Well, I was gonna go to the SATA program and they told me, they came and saw me, and they were like, get off their medication and you can go to our program. So I got off the medication and then they still denied me. And like, I've been here since January, away from my kids. Like, I was just hoping I could have another chance to do outpatient. I'm hoping for another chance, Your Honor. I'm begging for another chance.
Okay.
That's all I have to say.
This is the emotional core. Brittany pleads, I've been away from my kids, I'm begging for another chance. And you can tell, this isn't just legal strategy, it's desperation from a mom who feels trapped.
All right, so Ms. Brown, are you currently on your medications?
No, and I haven't been able to get back on them since SATA told me to get off of them so I can go to the program. And I got off of them and they just still denied me. And then I still haven't been able to get on meds. They haven't gave them back to me. And I've been off since April.
All right, so here's my question. The medication you've received, who was that through?
It was through here.
All right, so probation. Can we make sure that the jail knows that she's supposed to be on medication? So that,
So it looks like the eval is for MIC supervision only,
okay,
not for inpatient.
all right. So state. That was Mr. Dunn. My understanding is the state wanted to continue her.
Yes, they were asking to continue and extend for 2 years as well as DDRF, and we were asking. We weren't opposed to the continuation or to the extension, Your Honor. We were just asking for outpatient treatment, given the circumstances with the difficulty getting into DDRF and for status.
All right, and so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the COO, at least the main one. She was aware of that issue. Both violations that are alleged are still for Ms. Brown. I think there was just a typo in the name.
All right, so you have no objection to the oral amendment to the correct name in the violation of condition 15? All right, so Ms. Brown, have you ever been out of custody since you've had this charge?
Well, yeah.
All right, so have you been out of custody while you've been on probation before?
Yes, Your Honor.
All right, so,
I'm sorry.
no problem.
I've just been here since January.
All right, so you were placed on probation and then you were out of custody, is that correct?
Yes.
All right, and my understanding, we had DDRF was not a.
Now the judge digs into her medication issues. Brittany stopped taking meds because she thought it would help her qualify for a program, only to be rejected anyway. This is where mental health and the justice system collide, and defendants often fall straight through the cracks.
MIC, because I see where she is eligible for MIC, correct?
Yes, Judge.
So we'll place her on the MIC caseload. And do you have a case manager or anything of that nature with Center for Healthcare Services?
I need to get back over there on Fredericksburg to my doctor.
All right, so we're going to do a referral to Center for Healthcare Services. You're going to need to provide a release to probation. And you need to let them know who your case manager is. And you're to reside with your mother. And you're to make sure that probation has that address. Do you understand? Probation, is there anything else she needs?
The only other thing, Judge, would be if you want to order some type of outpatient component for her, a dual diagnosis outpatient.
All right, we'll do dual diagnosis outpatient. And my previous conditions will stand. And there's also to be no unsupervised contact with minors. And counsel, once she is stable on all her medications, you can always come back and change that. So for now, if you want to be around minor children, even if they're your own children, your mother or some adult that's approved by probation must be present. And that's just until you get back stabilized on your medications. You understand?
Yes, Your Honor.
Is there anything else you need from the court?
No.
All right, we can go off the record. Here's the thing. If there are issues or something's happening at your house, maybe you and your mom are not getting along. Because I tell people all the time that when you live with somebody else, if you're living in their space, their rules apply. No matter how old we are and it's our mom, if they want the television off at 10, TV must be off at 10, whether you're 12 or 30. All right?
Right.
If something happens where you all get in an argument and she say you have to leave, don't just throw your hands up. If she wants you to leave, you come back to court or call your probation officer and we'll figure something out. Don't just fall off the face of the earth and then you're back in blue. You understand?
Yes, Your Honor.
All right. Good luck.
Ends with some surprisingly human advice. Basically, follow your mom's house rules, don't disappear, and we'll work with you. For a case filled with legal language, this moment of simple life wisdom might be the most powerful.